Have you received a subpoena from the Department of Justice and are unsure how to respond? It's a situation that can be daunting. A Department of Justice subpoena is a serious matter, a tool used in both civil and criminal investigations. It's important to recognize that non-compliance isn't an option. The penalties for ignoring or mishandling such a subpoena can be severe, with civil and criminal contempt charges, obstruction of justice charges, and even fines or imprisonment on the table. This isn't a situation to navigate alone. Before we get going, please go to the link on the description page and immediately get to information to help you during this stressful journey. Please subscribe to this channel. Understanding the reason for the subpoena is crucial, and legal counsel can assist in preparing a defense strategy. Seeking immediate legal advice is highly recommended. An experienced attorney can help you assess the risks, develop a robust defense strategy, and guide you through the process of responding to the subpoena. Remember, you don't have to face this alone. Understanding the reason for the subpoena is crucial, and legal counsel can assist in preparing a defense strategy. Did you know that you have a constitutional right not to incriminate yourself? This right is one of the cornerstones of our legal system, and it's particularly critical when you're facing a Department of Justice subpoena. Navigating these waters can be tricky. It's not about hiding the truth, but about ensuring your rights are protected in the process. Hire legal counsel at Watson & Associates LLC. An experienced attorney can guide you through this labyrinth, helping you respond to the subpoena without inadvertently incriminating yourself. They understand the intricacies of the law and know how to navigate the complex network of regulations and protocols involved in responding to a DOJ subpoena. Legal counsel can also help you exercise your rights in a way that doesn't land you in hot water. For instance, there may be information you can withhold based on the attorney-client privilege or the privilege against self-incrimination. But this isn't a decision to make lightly or without professional advice. Withholding information based on attorney-client privilege or the privilege against self-incrimination is possible. Legal counsel can assess the risks of facing civil or criminal charges and develop a defense strategy. So, when that subpoena lands on your desk, remember, silence can sometimes be the most powerful statement you make. Are you aware of the penalties for withholding information and not being honest in your response to a DOJ subpoena? The consequences can be severe and far-reaching. Failing to provide full and accurate information when responding to a DOJ subpoena could land you in hot water. This could lead to additional felony charges or even sanctions. Imagine this. You're already under federal investigation, and now, by withholding information or not being forthright, you're compounding your legal issues. This is no small matter. We're talking about civil contempt charges, criminal contempt charges, obstruction of justice charges, and potentially even fines or imprisonment. It's also worth noting that these penalties aren't just for outright lies. Even inadvertently omitting critical information or providing misleading responses can lead to trouble. It's a tricky landscape to navigate, and one wrong step could lead to a steep fall. Being truthful and transparent in your response to a DOJ subpoena is not just the right thing to do, it can also save you from further legal trouble. Did you know that DOJ, SEC, and OIG subpoenas often come with confidentiality requirements? That's right, these legal documents are not just a simple request for information. They come with a set of rules that must be strictly adhered to. One of the most critical of these is the requirement for confidentiality. This means that the existence of the subpoena or investigation cannot be disclosed to anyone without proper authorization. Think about that for a moment. This includes your colleagues, your supervisors, even friends and family. And it goes without saying that the media is strictly off limits. The confidentiality requirement is not a suggestion or a guideline, it's a mandate, a legal obligation that carries serious consequences for non-compliance. So what happens if you violate this confidentiality? Well, it's not pretty. Unauthorized disclosure can lead to criminal charges. You could find yourself in court, facing penalties that could include fines or even imprisonment. Remember, violating confidentiality can lead to criminal charges. It's critical to comply fully and on time with DOJ and SEC subpoenas. Are you aware that in government contract criminal cases there are unique rules and regulations to consider? These cases are not your everyday legal disputes. They involve intricate laws like the False Claims Act, which targets fraud against the federal government, and the Buy American Act, which encourages the purchase of American-made goods. Subpoenas related to these acts bring their own unique challenges and complexities. In particular, the Buy American Act can lead to subpoenas that require a deep understanding of both domestic and international trade laws. And when it comes to False Claims Act cases, the stakes are high as they often involve allegations of fraud, which can lead to hefty fines and even imprisonment. In these situations, it's not just about understanding the law, but about knowing how to navigate the legal system. One critical step is placing a legal hold. This is a process that ensures all relevant information is preserved for potential use in the litigation process. But remember, these laws are complex and the consequences of a misstep can be serious. In times like these, you may want to seek an attorney that is experienced in government contracting and False Claims Act cases. When facing a DOJ subpoena, it's crucial to have experienced legal counsel by your side. Retain the Watson & Associates law firm, a wealth of top legal expertise in a sea of uncertainty. As a nationwide government contracts and defense law firm, we bring to the table over 2 decades of experience in navigating the complex labyrinth of federal law. With a team comprised largely of former federal government attorneys, we possess an insider's understanding of the system. We've seen the workings of the government from the inside out, and we know how to leverage that knowledge to your advantage. Our firm is adept at handling a broad spectrum of cases. Whether it's a subpoena related to the Buy American Act, the Trade Agreements Act, healthcare SBA, or small business fraud, our seasoned attorneys are equipped to handle the unique challenges each case brings. We understand the weight of a DOJ subpoena. We know the stakes are high and the pressure can be overwhelming. That's why we are committed to providing our clients with a comprehensive and strategic defense. We dedicate ourselves to ensuring that your rights are preserved and your best interests are always at the forefront. Our attorneys are skilled in managing the delicate balance between compliance with the subpoena and safeguarding your constitutional rights. We understand the importance of confidentiality, and we are proficient in establishing legal holds, an essential step in preserving relevant information and avoiding serious penalties. At Watson & Associates, we believe in the power of a well-prepared defense. We can work relentlessly to negotiate or challenge the grounds of the subpoena when appropriate, to minimize the risks of civil or criminal charges, and to prevent additional felonies from tarnishing your record. So, when facing a DOJ subpoena, don't face it alone. Seek the experienced counsel of Watson & Associates. We're more than just defense attorneys. We work side by side with you, are as team in the face of adversity, your guides in the world of federal law, and your best defense against the daunting power of the Department of Justice subpoenas.